So what do you have to show about your affiliated company abroad to qualify for an L1A visa? These are several requirements that will need to be demonstrated to USCIS. So I'll explain them, some of the types of evidence that you would need, and the common mistakes that lead to denials. Your affiliated company could be your parent company, a subsidiary of the company here in the United States, or another subsidiary of a common parent company. Regardless of the affiliation, the employee has to have been working at a company that is currently affiliated, active, and doing business. But beyond being active and affiliated, the company must also have enough employees to support a management or executive position. This will be one of the main things the USCIS looks at when reviewing an application. In terms of evidence, you should be prepared to provide the following. Evidence of incorporation. This could include business licenses or articles of incorporation. Evidence of continuous business activity, including recent contracts, invoices, tax receipts, or brochures. Evidence of financial ability to support the employee, including tax reports and annual reports. Evidence of affiliated company's corporate presence abroad, including pictures of the corporate building and interior, lease agreements, etc. Evidence of the beneficiary's 1 year of employment, including payroll and employment letter. In addition, official corporate documents such as board resolution deciding to set up a U.S. branch are very, very helpful. And you will definitely need to have an organizational chart with the total number of employees, the position held by the beneficiary you are bringing to the United States, and resumes and diplomas for their subordinate employees. I know this can seem like quite a lot of evidence, and it is, but it is doable. However, there are some common mistakes that companies make in these L1A applications that results in denials and a lot of wasted time, money, and efforts. The first is they don't really have enough employees to justify bringing a manager or executive to the United States. Now, there is no strict regulation on how many employees you need, and it is something subjective, but you obviously need enough employees to require a general manager. Another common mistake is that the foreign affiliate is too different in nature from the US affiliate. So say, for example, two companies were both subsidiaries of the same parent company. However, one was a consulting firm and the other was a manufacturing firm. It may be difficult to prove that the manufacturing manager was needed as a manager in the consulting firm. This also ties into the requirement that the transfer of the employee must be reasonable and feasible. That means, for example, that the beneficiaries need to be qualified for the position they're coming in. If they have been chief marketing manager, for example, it might be a little bit difficult to prove that they're qualified to become a chief technology officers. This is why you should speak to a qualified and experienced immigration lawyer like me, who can analyze your situation and help you avoid these costly mistakes. If you have any additional questions for me or my team, please contact our office to set up a consultation.